So the Supreme Court just sided with the ATF, striking down the injunction which prevents the ATF from enforcing their new rule. So let's talk about what just happened. But real quick before we jump into this video, if you think these ATF rules are clearly unconstitutional and must be struck down, go ahead and hit that like button and subscribe. Also want to mention that the Gundy's Awards are coming around again, and the nomination and the categories are now open, so you can nominate various creators, myself and others included. I will leave a link down below. A couple years back, we won Top 2A Voices. Last year, we were also in the top 4 for Top 2A Voices. I would love to be in the top 4 again. So again, you can nominate myself and other creators using the link down below that you can find in the description section and then also in the pinned comment. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be discussing how the Supreme Court has once again sided with the ATF and has protected the ATF's current Second Amendment violations. For the second time, the ATF went up to the Supreme Court asking for the Supreme Court to vacate a limited injunction that was upheld by the Fifth Circuit. If you don't recall, recently the Fifth Circuit issued an order that upheld a limited injunction which prevented the ATF from enforcing their frames and receivers rule against specific companies. Those companies were Defense Distributed and then also Blackhawk Manufacturing Group, which is 80% Arms. The ATF then challenged even a limited injunction being in place and asked for the Supreme Court to take emergency review of the case and to ultimately vacate that injunction. And we just got an order from the Supreme Court, which is once again siding with the ATF. Now, originally in this case, the original plaintiffs, FBC and Tactical Machining, sought a preliminary injunction to halt the enforcement of the ATF's new rule, essentially while this case was making its way through the process. And on review, Judge Reed O'Connor granted a limited injunction against the ATF, which prevented the ATF from enforcing the rule against that one company, Tactical Machining, and their customers. After that, other companies like Blackhawk Manufacturing Group, 80% Arms, and then also Defense Distributed sought to intervene in the case as new plaintiffs. They also asked for the court there, Judge O'Connor, to grant them the same type of limited protections that was granted to the other company, Tactical Machining, and ultimately Judge O'Connor did extend those protections to the companies and then their customers. After the preliminary injunction stage, the plaintiffs sought to win the entire case, and FBC asked for a motion for summary judgment. And in response and on review, Judge O'Connor did grant the motion for summary judgment and vacated the frames and receivers rule in its entirety, and that was a nationwide vacatur of the rule. Well, of course, the ATF was not going to let that summary judgment sit, so they filed an appeal up to the Fifth Circuit. Then the ATF also sought a stay of the vacatur from the lower court and then also from the Fifth Circuit. They did not want it to be enforced. They did not want that nationwide vacatur to be in place, but ultimately both Judge O'Connor and the Fifth Circuit denied those stay requests. That then led the ATF going to the Supreme Court for the first time in this case and seeking an emergency stay from the Supreme Court. And on that first attempt, in a 5-4 decision, the Supreme Court agreed to stay the enforcement of the summary judgment decision, which vacated the rule nationwide. And in that 5-4 stay, you had Justices Barrett and then also Justice Roberts join the liberals to decide in favor of the ATF. Through that order, the Supreme Court stayed the nationwide vacatur while the Fifth Circuit is reviewing that summary judgment appeal, which is still ongoing. And I want to note that arguments have taken place at the Fifth Circuit 3-judge panel level on the motion for summary judgment, and we're still waiting for that decision. Now, after the Supreme Court issued that 5-4 emergency stay on the first time, 80% Arms and Defense Distributed went back down to Judge O'Connor and sought for an emergency motion for a preliminary injunction. They asked for Judge O'Connor to put back in place his prior preliminary injunctions that protected their company and customers. Essentially, they had to do this because the nationwide vacatur was put on halt because of the Supreme Court. And on review, Judge O'Connor agreed and granted the limited injunction. Of course, the ATF could not live with that loss, so they filed an appeal up to the Fifth Circuit, arguing that Judge O'Connor directly defied the Supreme Court in that 5-4 order and is trying to circumvent what the Supreme Court said in their emergency order. Well, on review, the Fifth Circuit heard the arguments, heard the emergency motion, and issued an order which ultimately upheld the new limited injunction that Judge O'Connor issued. The Fifth Circuit did vacate part of the Judge O'Connor new limited injunction, specifically the broad protections for all customers of all those companies. But a big part of them doing that had to do with the ATF representing to the court that they were not going to enforce the rule anyways against customers. So at that point, the Fifth Circuit said, we don't need that broad protection because the ATF is saying they're not enforcing it against customers anyways. We want to limit this just to the parties and those companies that could be impacted. Now, again, the big issue with taking the ATF's words that they're not going to enforce against customers is that the ATF flip-flops on their position quite often, and we are seeing that right now play out with some of the other cases that are being dealt with the ATF's pistol brace rule and then the FRT issue. If you're not aware of what's going on with that and the ATF going after people despite multiple injunctions, which are essentially preventing their enforcement of those rules, go watch my last video that I put out. I will link it down below where you can watch that video. But the ATF, again, not staying true to their word, defying court injunctions and still going after people. Now, after the ATF lost again at the Fifth Circuit level, they responded by going up to Supreme Court on an emergency application once again and asking for the Supreme Court to vacate that injunction, that limited injunction. The emergency request went to Justice Alito originally, who is in charge of the Fifth Circuit. Each justice is in charge of certain circuit courts. Justice Alito is in charge of the Fifth Circuit. It went to him originally, and what he did is he did grant a temporary administrative stay on the new injunction. That temporary stay was in place until October 16th, which is when the Supreme Court had to decide what they were going to do in this case. So all eyes were on October 16th. And we got the order from the Supreme Court, which is that they are once again going to side with the ATF, and they are vacating the limited injunction that was issued by Judge O'Connor. On the docket, the order of the court reads that application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The September 14th, 2023 order of the United States District Court for the Northern District of Texas is vacated. That's essentially all it says. This means that the Supreme Court has now decided to strike down the nationwide vacatur first. That was the first review. And then also they are striking down the limited injunction that protects only those companies. So that is what the Supreme Court said. They said no nationwide vacatur and no limited injunction. What is interesting about this specific order is the fact that we did not get a poll of the judges who decided to join to grant the vacatur or deny the vacatur. Last time we found out that Justice Barrett and Roberts were the ones who joined the other side, but this time it's silent on maybe who joined that. Now, what does this mean going forward? A lot of you are probably curious about what does this mean? Well, while this case makes its way through the process for the foreseeable future, the ATF will still be able to enforce this new rule against unfinished frames receivers, essentially 80%ers. This will also be despite the fact that maybe we get a positive decision out of the Fifth Circuit 3-judge panel. Maybe they agree that a summary judgment should have been granted, that the nationwide vacatur was appropriate. But even if that happens, it's not going to lead to anything positive. It will be a positive decision, but they won't be able to issue any relief potentially. Essentially, now the only positive thing for this case is for it to move forward on its merits and eventually make its way back to Supreme Court, where hopefully the Supreme Court will review this and then strike down the rule in its entirety. So not super surprising, but this order from the Supreme Court does put us in a bad position, especially moving forward in this specific case. It also is going to significantly hurt those companies like 80% Arms, Defense Distributed, and others who are going to likely be, harmed by this rule, that their businesses are going to be harmed by this rule. I also have some concerns with the pistol brace injunctions that were issued in the Mock v. Garland case and the NAGR case. I think the ATF may feel confident enough now to seek some sort of emergency review from the Supreme Court to stay those injunctions, which protected those two-way organizations and then also their members. To me, it would be a hard sell, for the ATF to do that because of how they've waited on those. Those protections have been in place for a while. But, I wouldn't be surprised if the ATF, came up with some excuse of why they did not act immediately and go to the Supreme Court. So that's also something we're going to want to keep our eyes on because I think this could bleed over into the pistol brace issue. So that's the critical update that just happened. The Supreme Court granted the ATF's request to vacate the injunction, which provided limited protections for 80% companies. Now we're going to have to wait and see how the Fifth Circuit rules on that summary judgment. And hopefully this case proceeds forward fast on its merits and we kind of get through the rest of the process fast. But as we get more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. Also want to mention that I was looking at my analytics and about 60% of all viewers here on the channel are not actually subscribed to the channel. I just want to ask, if you guys are watching the channel, if you watch the channel frequently, please consider subscribing to the channel. That really does help the analytics. It helps to push this out to more people. And also, if you're finding value in this, why would you not subscribe? It's for free. And also, for you guys who have been subscribed for a while, make sure that you have, the bell icon clicked and all notifications on, because I know a lot of people, say that they're not seeing these videos. One of the ways you can ensure that potentially you do see them is to have all notifications on, and then just double check to make sure you have not been unsubscribed from the channel, because YouTube does that quite often. So again, just check your subscriptions. But regardless, thank you guys so much for all of your support. And as always, Thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.